Employees typically organize into unions by one of two methods. Either a state or national union will contact them about organizing to become union members, or the employees themselves approach the union about joining. When it's the employees approaching the union, it's often because one or more are unhappy about some new policy, working condition, or change in leadership. It is also often the case that employees will approach the union because they have reason to believe their jobs are threatened. In either case, a local government agency should be aware of its rights and obligations. That's what we'll explore in this presentation. Union certification is the determination that a particular union qualifies as the bargaining unit because it has the support of a majority of workers. The Minnesota Public Employer Labor Relations Act, known as MPELRA, governs the extent to which an agency can participate in this process. It includes what an agency can and cannot do to encourage or discourage union membership. There are three major parts of a union organizing effort. First, union petition. The union must show that it has at least 30% of identified members interested in unionizing. Second, determination of the appropriate positions. The BMS decides which positions are appropriate to include in a bargaining unit. This is often called unit determination. And finally, the campaign and election. The employees occupying appropriate positions vote on whether they want to be represented by the union. The Bureau of Mediation Services, known as the BMS, is the state agency responsible for overseeing labor relations in Minnesota, both in the public and private sector. It plays a large role in determining whether a union is appropriately and legally certified to represent a group of employees, called a bargaining unit. The first formal step for a union or employee organization seeking to represent employees is filing a petition for certification of exclusive representation. Petition requirements and limitations on filing a petition are outlined in Minnesota law. The petition for certification of exclusive representation must be in writing and include the following: other interested employee organizations or exclusive representatives, whether there's a labor contract in effect and its expiration date, the type of public employer involved, the appropriate number of employees included in the proposed or previously determined appropriate unit, the proposed or previously determined appropriate unit description, confirmation that at least 30% of the employees in that unit support the intent of the petition, the date the petition is signed, and the name and title of the person signing the petition. Sometimes a union will directly contact an agency, city, or other local government agency for a list of all employees listed in certain job titles. The union organizing employees has the right to request any public information about the employees from that agency. Agencies should not provide the union with home addresses, as they are considered private data under Minnesota Government Data Practice Statute. The employer must provide the Bureau of Mediation Services with home address later in the process. The BMS will then provide the union with home address through the process, as we'll talk about in a moment. The primary limitation on filing a petition for a non-union group is that it cannot occur within 1 year of a prior representation election. The union is required to submit authorization cards showing that at least 30% of employees of a proposed unit wish to be represented by the union. Since the union ultimately needs 50% plus one of the votes to win an election, it will usually have well over that 30% threshold needed at this stage. Authorization cards must contain the following information: a statement clearly reflecting the employee's support for the purpose of the petition, the clearly printed name of the employee making the authorization, the signature of that employee, and the date the employee signed the card. After a petition is filed with the BMS, the next step in a union or employee organization seeking to represent a bargaining unit is to define the appropriate bargaining unit. The BMS must take into account the following factors in determining whether positions belong together in a bargaining unit. First, positions covered by the same classification or compensation plan. Positions in the same professions and skilled crafts and other occupational classifications. Relevant administrative and supervisory level of authority, geographic location, history, the extent of organization, recommendation of the parties, and other relevant factors. The law also provides some specific prohibitions against certain types of employees being placed together in the same bargaining unit. Essential and non-essential employees, as those terms are defined in MPELRA, cannot be placed in the same bargaining unit. This means that police officers, who are defined by state statute as essential, cannot be in the same unit with clerical staff of the police department, who are not essential as defined by state statute. Likewise, supervisory and confidential employees cannot be included in the same bargaining unit as employees who are not supervisory or confidential. However, supervisory and confidential employees may be included in the same bargaining unit. So why does this all matter? A primary reason for not mingling essential employees with other employees is that essential employees have the right to binding arbitration in order to settle union contracts. Other types of employee groups must strike if they cannot reach settlement with a local government agency. All of the employees in the same unit need to have the ability to settle their contract in the same manner. So let's move on. If the agency determines it does not agree with the union on all of the job classes to be included in the described bargaining unit, then the matter is determined at a unit determination hearing. The BMS will utilize this unit determination hearing to make the final determination on any disputed issues regarding the unit description and employees included within the appropriate bargaining unit. Following receipt and acceptance of the petition for certification of exclusive representation, BMS will issue a written maintenance of status quo order. This document is the employer's first official notice of an attempt to organize a group of employees. The purpose of the maintenance of status quo order is to make sure the election occurs in what's known as a laboratory condition, free from improper influences by the employer interfering with employees' rights to form and join labor organizations. The BMS has noted it uses this administrative tool to recognize that, quote, the fact that the employer controls all aspects of an employee's employment and prohibits the employer from using this control to affect the outcome of the election, unquote. The order basically tells the agency it should not make any changes in the terms and conditions of employment for the group of employees under consideration for unionization. Generally, this will mean no planned or unannounced changes regarding pay increases or decreases, including proposed and planned merit increases, changes in job descriptions, substantial changes in work shifts, overtime practices or benefits, or other significant employment practices. The agency should also take steps to notify its supervisors, managers, and sometimes elected officials about the fact that it's received a status quo order. Any action by any individual or group of individuals that have the authority to act on behalf of the agency may be perceived as a violation of the status quo order. Violation of this order could bring a charge of an unfair labor practice. Well, there's a large section of MPELRA that deals with unfair labor practices. Here are 4 practices that most closely relate to union organizing and election activity. They include dominating or interfering with the formation of any employee organization or contributing support to it, discriminating in regard to hiring or tenure to encourage or discourage membership of an employee organization, discharging or otherwise discriminating against an employee because the employee has signed a lawful affidavit, petition, or complaint, and finally, violating rules established by the Commission, the BMS, regarding the conduct of representation elections. So those words are all fine and good, but what does it really mean? Some examples of practices that could be seen as unfair labor practice during union organization include promising employees better benefits or pay increases if they vote against the union, threatening or implying that if the employees unionize, management will get tougher, threatening layoffs if the union is voted in, promising to promote an employee after the union organizing campaign if he or she discourages others from voting in favor of the union, and taking any negative employment action against an employee because of his or her involvement with the union organizing drive. Between the time of unit determination and the union election, the employer may campaign in favor of remaining union-free. However, there are some things that an employer simply cannot do. They include making threats against employees for voting in favor of the union, saying such things as the city will have to lay off some jobs if a union is voted in, making promises, like saying the agency will give larger than normal increases next year if you vote down the union, discharge or discipline of an employee because of union activity, or questioning an employee regarding his or her actions and opinions. Other things agencies cannot do include spying on union activities or asking about union matters such as meetings, discriminating either in favor or against union activity, like giving better shifts to employees who have expressed a negative viewpoint about having a union, and finally, asking employees when they're hired or after they've been hired whether they belong to a union, carry a union card, or have ever signed on a union authorization card. It's equally, if not more important, to know what the employer and its management can do. This includes listening to, but not soliciting information from employees if it's voluntarily given, but discouraging disclosure of names of union advocates, enforcing rules uniformly, without bias, and in accordance with past practice, regardless of an employee's activity in union organizing campaigns. However, you should be prepared to justify any action taken against a union supporter, stating their opinions about unions, provided such statements are not a promise or a threat. The city could say something like, "It's our current pay and benefit structure compares very favorably to agencies that have unions or don't have unions paying union dues." Stating any factual information, like the union you're seeking charges dues in the amount of X, and finally telling the agency prefers to deal with them personally on a one-on-one basis rather than settling grievance through a union or another outside agent. An employer can also tell employees about current benefits they enjoy without making promises or threats about future benefits, telling employees that no matter how they vote, the decision will not be held against them in respect to future wages or promotions, telling employees that if an election takes place, the election is done by secret ballot, and explaining to employees that a mere election of a union does not guarantee any specific change. Instead, the agency will negotiate with the union on all terms and conditions of employment. The BMS will then issue a voting eligibility list containing the names of employees in the union. This is the list of individuals who will be able to vote in the election. Be sure to check this list against your own to make sure they match. Notify the BMS immediately if you see any discrepancies. The BMS will then issue and mail an election order to the employer and the union at least 10 calendar days prior to the date of the on-site election or the date of the mailing of ballots for a ballot election. This order will identify the appropriate bargaining unit, establish the cutoff date for voter eligibility, include a list of eligible voters, include a sample ballot, establish campaign and election rules, provide the parties to appoint election observers, identify the date, time, and location of an on-site election, and provide for absentee ballots, identify the date of mailing ballots in a ballot mail-in election, including all other conditions which are necessary to conduct a fair election, and providing the posting for an agency of the election order and attachments. In the event the union obtains a majority votes cast in its favor, it will be deemed the exclusive representative. If more than one exclusive representative is seeking to represent the group, and none of these groups attains a majority of the votes cast, there will be a runoff election between the top two organizations. And finally, if the majority of voters choose no representation, or there is a tie vote between representation and no representation, the BMS will declare the union is not the exclusive representative and lift the existing status quo order.